You're watching Inside Automotive with Jim Fitzpatrick.
The FTC has banned almost all non-compete agreements, so today we are learning more about how dealers may be impacted. We're pleased to welcome back Len Bellavia, who's the founding partner of the law firm Bellavia Blatt, also known as dealerlaw.com. So Len, thank you so much for joining us on the show today to discuss this. While not everybody, as you know, at the dealership is under a non-compete, there are, however, a number of people in a dealer group, such as the general managers and fixed ops directors and things like that, that where a dealer did sign them up to a non-compete, and maybe rightfully so. I mean, these guys and girls are making a whole bunch of money, and they're learning a lot of different things working for dealer groups and such. And as you know, there's other dealer groups want those leaders at those well-run dealerships. And so if you don't have something like this, you're in trouble, right?
Well, first of all, thank you for having me on again, Jim. Pleasure to be with you.
Sure.
Yeah, I mean, the automotive industry is hard enough to find good employees,
right?
As a general statement. And then, once you train, educate, pay them, you want to make sure that whatever, confidential type information that has been imparted to them is protected forever.
Sure.
And, oftentimes, there's a balance that has to be struck. Dealers understand that if they want to hire people, they can't, nail them down too much with non-competes. But on the other hand, if the position is a key position, such as a fixed ops director, a general sales manager, general manager, they're going to come across certain information that should not be shared with anyone else. And that has to be balanced against the Federal Trade Commission's interest as of late in making sure people can go from position to position, unfettered, so that their careers are not, jeopardized in any way. So
where did all this come
the
from?
auto industry is kind of an interesting case because it's a narrow group of professionals or people with intimate knowledge of a very misunderstood industry, and there's a need for dealers to protect themselves, and there's also a need for employees to be able to be unfettered in their decision making as far as where they want to go next.
Right. Where did all of this come from? Why did the FTC decide to look at this now and change the rules?
Well, it's interesting because the FTC has put out numbers that I don't even know how they could prove these figures, but they claim that 100 million workers, employees, are subject to written non-compete agreements. Now, these are not recorded documents like a deed or something related to a real estate transaction. So how they came up with that figure is a mystery. I've seen other estimates to be 50 million. I think it's really just to create the impression for their narrative to say, there's time for a change.
Right.
And those that oppose this are saying, look, non-competes are vital. We, as lawyers in law school, the professor always says, well, if you work for Kentucky Fried Chicken in their food laboratory, do you think it's fair that they should sign a non-compete? I mean, look at people who work in the White House, and they leave and then they write these damning books about what happened in the White House. Is there a legitimate interest to protect the confidential information and prevent people from competing, utilizing the information that they learned from someone who paid them presumably an awful lot of money over a long period of time, and they have a business interest at protecting? So it's not any, you can debate both sides of this.
Sure.
But why did this happen now? I think, the nature of the current administration is to, cater to the rank and file, so to speak, more than, the corporate America. But, the debate is that corporate America has a legitimate interest in preserving the integrity of their proprietary information, and not have an employee who's benefited greatly over a long period of time go out and steal all or poach employees and poach business records and customer lists and all the things that could put a real hurting on an employer if those things are not protected.
No, there's no question about it. And where does it stop? I would imagine that there's a number of high-tech companies out there that are working on all types of technology where you wouldn't want somebody to be leaving to go to a competitor to go, hey, I got the special sauce here, and I know exactly how to build that technology for, you know what I mean? I mean, I pick technology, but obviously there's so many other types of companies out there that would be hurt by something like this. Right?
Yeah, well, the devil is in the details here because there are still protections against those type of infractions. What's being quote unquote, banned or outlawed are pure non-compete agreements.
Yeah.
Non-compete agreements are different than confidentiality agreements or
Sure.
non-solicitation agreements. So non-compete agreements essentially say when you leave here, if you leave here, you can't compete in the same industry. Typically, it's confined to a specific geographic area and a specific period of time. So it might say you can't, if you're a Ford general manager, you can't work in a Ford dealership within 20 miles of your existing employer.
Sure.
And for a period of 3 years. Now, is that reasonable? Is that fair? That could be debated.
Yeah.
But what's not disturbed is the prohibition against taking customer lists with you, because anybody, especially in this day and age, you can
click on the mouse.
Customer lists in a matter of minutes, and, the day you're quitting, and take it with you.
Yep.
And then the other prohibition that remains intact, even with this FTC ruling, is the prohibition, if an employee signs an agreement that says this, against soliciting other employees from that particular employer or customers. So, you can take a seat back and say, look, this is a dramatic change in the way businesses operate. However, if there is a secret sauce, so to speak, and I'll try and, analyze this in the context of an automobile dealership, there are things that are still going to be protected, notwithstanding the abolition of the non-compete, and that is confidential information. And what is confidential information? Well, when you start out with the Kentucky Fried Chicken example, you can say, well, nothing's as important as that. That everybody understands.
Sure.
But what's confidential at a dealership? Well, is it methods, approaches, tactics, discounts, methodologies in terms of selling, buying used cars, discounting off of customer pay? I mean, you have a whole host of things that the owners of dealerships would argue, well, you learned about this on our dime, and therefore it's confidential information. Now, the employee would say, well, wait a second. Some of this stuff is generic. You can go into, automotive news and read about all these different, better approaches.
Or they could have even come with that knowledge already. That's why the dealer hired them, to say, hey, come on in here, turn my store around. They do. And it's like, well, actually, the employee might have been teaching the dealer a few things that they never knew before.
And therein lies the rub, because the dealer will always take the position that whatever you learn here, you learn from me. And the employee will say, well, wait a second, I worked at 5 dealerships before I got here.
Sure.
And some of the things I implemented here were in my own head.
Yeah.
They had nothing to do with my job here. So that's what, I think it boils down to, what is sacrosanct? And that courts generally, because before the FTC regulations, these issues have historically been decided in state courts. And the general interpretation is, well, what's the balancing act here?
Right.
So if customer lists, clearly customer lists are unique. You're not going to find that in the public domain. I mean, you could argue that I can run registration profiles and find out who bought cars where. But typically courts will recognize that customer lists belong to the employer, even if you brought in the customers based upon your skills.
Right.
So that generally is protected. Pricing. Now, there's a good example of something that really isn't truly confidential proprietary information, because most dealers know what their competitors are charging.
It's all
what
online.
Their grosses are, because they just ask customers, what price did you get from the next dealer down the street?
Yeah.
So does that really rise to the level of proprietary confidential information? Probably not. Certain discounting for fleet business, well, that might not be something you can find out from a customer walking into the showroom. So that, I think, would be characterized as confidential proprietary information, which is not upset by this FTC ruling.
Sure.
So if a dealer were to come in and say, what do I have to do to put into this agreement that I want my new manager to sign? Well, a couple of answers to that one. First of all, the timing of this FTC, this new rule, doesn't go into effect immediately. It goes into effect 4 months after it's published in the Federal Register, which was just recently published. So I think that brings it to the first week in September.
Okay.
So it's fair game between now and the beginning of September, subject to certain lawsuits that have been filed by a couple of pretty prominent plaintiffs, including the U.S. Chamber of Commerce, are challenging this, saying the FTC didn't have constitutional and regulatory authority to do this. So it's conceivable that this will not roll out in September, because these plaintiffs are seeking injunctive relief from the courts to put a hold to this, because they're saying, look, the FTC shouldn't have this authority as a federal agency. This should be something that's governed, by Congress.
Yeah.
Because it impacts too many people and too many businesses, and there's too many hundreds of billions of dollars at stake. So it's possible that this new rule will not see the light of day as quickly as the FTC thinks it will. So I would say first to dealers, hold the phone, don't panic, don't change the way you're doing business. If it turns out that these lawsuits are unsuccessful, and it looks like either September or some later date that the rule will impact, then what has to happen is you have to retweak your existing agreements and take out the non-compete.
Okay.
But tighten up the non-solicitation and the confidentiality, or we call NDA, non-disclosure agreements, because they still survive. So I say the first step is sit back and watch what's going on in the judicial system with these lawsuits. And then based on that, either they will totally thwart the efforts of the FTC, and there's not going to be any change whatsoever, or there'll be some middle ground, and then dealers will have to respond. They have to keep an eye on the clock too, because once the courts decide, they'll probably have a deadline, and then the dealers have to step into action, because one of the components is you got to notify all of the employees, both present and past, that they're no longer bound by the non-compete agreement.
Great. Just in case you didn't know, folks, you can now go out and work wherever you want.
That's right.
That's great.
Yeah. But the FTC made it a little bit easier because they prepared a template, a form that can be sent to a customer. So it kind of gets lost in the legalese, and maybe it won't be as resounding as it may sound.
Sure.
That'll embolden a former employee to compete and do things they weren't otherwise permitted to do.
Right.
So there's a lot of nuances to this new rule.
From a political standpoint, is this something that if it gets kicked to November and then former President Trump becomes the next, the president-elect, would he come in and look at something like this and go, oh, no, we're kicking this out?
Well, look, that is a function of how dysfunctional a new Congress, a new administration would be.
Yeah.
So if it's determined that, this is really the role that Congress should play, it's not automatic, even in a Trump administration, that, this will be disturbed. So your guess is as good as mine. And that's why I think what's important now is for dealers to be aware of it.
Yeah.
Speak to their attorneys about what they should or shouldn't do. Should they sit on the sidelines and wait and see what happens with these lawsuits or the new administration coming in?
Sure.
Worst case scenario, this all happens, before the election. Right now, it's slated to happen in September before the election.
Okay.
So if the courts do not disturb it from these, U.S. Chamber of Commerce lawsuits, and Ryan's another plaintiff, it's a tax consulting business that started a lawsuit, and there'll be others, I'm sure.
Yeah.
So if they're not successful, then dealers have to get ready to do a lot of things: send out the notices, revamp their existing non-compete agreements to take out that.
Hey, one last question before I let you go, and I appreciate all the time you've given me. In the event that you've got somebody that comes in and you say, hey, they refuse to sign a non-compete, okay? Or maybe even one of the other agreements, the non-disclosure, agreements or what have you. Is it okay to let that person still come into your employment? Even though you had everybody else sign one? Is it one of those either everybody signs it or nobody signs it kind of thing? Or can you decide on a case-by-case basis who? Yeah,
there's no discriminatory implications legally if you decided not to have one signed by some superstar who's coming in. That's a decision that a dealer can make, whether they want to waive it for a particular person they feel it's worth the risk. So there's no parity issue or
all right. So
problem.
You can case by case.
You can do it case by case.
Interesting.
Absolutely.
Yeah. Len Bellavia, thank you so much for joining us. Very much appreciated. He's founding partner at Bellavia Blatt PC. So thank you so much for joining us today. Also, you can find him at dealerlaw.com. We'll show the information on the screen here. Very much appreciate all the time you've given us. This is a hot topic for a lot of dealers out there, and I think your insights are invaluable to them. So thank you.
Always a pleasure, Jim. Thank you for having me.
Thanks.
Thanks for watching Inside Automotive with Jim Fitzpatrick.